Give your introduction.
So I am Paras Ahuja. I am currently a resident of District Panchkula in the state of Haryana. So I graduated in the year 2022 from National Law University, Jodhpur. So I consider myself as a compassionate and a goal-oriented person. And in my free time, I like to write on topics of my interest and engage in conversations with my parents.
What is the meaning of your name?
So Paras is a mystical stone. It's a touchstone which is believed to have the ability to convert iron into gold.
Okay. Why do you want to become a judge in HP, particular in HP?
Specifically in the state of HP, because my temperament, the kind of person I am, and the kind of life that I want to live, it resonates a lot with the state of Himachal Pradesh. So be it the serenity of the state of Himachal Pradesh, the pious ambience, the spiritual inclination of people in this state. So the fact that people here are so culturally rooted, and the fact that it is situated in the lap of the nature. So all those things have really inspired me to prepare for HP Judiciary in specific.
Okay. Who is the Chief Justice of Supreme Court at present?
Sir, Honorable Justice D.Y. Chandrachud.
Okay. What are the qualities of judges?
So a judge should be someone who is able to maintain a calm, composed, and poised demeanor throughout. A judge should be able to apply his mind in an unbiased and fair manner to the facts of the case, and should also be very perceptive. He should be able to sense the demeanor of the witnesses, see through the legal jargon to locate the human story behind it. So apart from that, judge should be someone who is legally who has a good legal knowledge, who is competent in that respect, and is of high integrity.
Okay. How many judges are there in Supreme Court at present?
So there are 34 judges in Supreme Court, including the Honorable Chief Justice of India.
Okay. Who was the first woman judge of the Supreme Court?
Sir, Honorable Justice Fatima Bibi.
Okay. When the Constitution of India was adopted?
Sir, 26 November 1949, sir.
Okay. Then, what is the meaning of judicial review?
So judicial review refers to the power of the high courts and the Supreme Court to adjudge on the validity of legislative and executive action.
Okay. What is the Uniform Civil Code?
So Uniform Civil Code is a concept wherein all the people will be governed by the same personal law, as opposed to being governed by religion-specific personal laws.
Okay. How many districts are in Himachal Pradesh?
So there are 12 districts.
Please, कुछ नाम बताएंगे कुछ district या?
Certainly, sir. So there's Shimla, Una, Hamirpur, Bilaspur, Sir Kullu, and Sir Sirmaur is there. Sir Lahaul Spiti is there.
Okay. कुछ मेजर रिवर हिमाचल के अंदर कितनी रिवर्स है मेजर रिवर हिमाचल के अंदर
So majorly five rivers. Sir Satluj, Ravi, Chenab, and Yamuna, Beas river is there in Himachal.
Okay. Summer capital of हिमाचल प्रदेश कहाँ पे?
Sir Shimla.
और winter capital?
Sir Dharamshala.
Okay. Then what is anticipatory bail?
So anticipatory bail is granted to a person who is under an apprehension that he would be arrested in charge of a non-bailable offense. So it is granted before arrest to protect a person from custody in the event that he is arrested in future.
Okay. What is the life of the anticipatory bail?
Sir, there is no limitation as to what can be the life of the anticipatory bail, as provided as held by the Supreme Court in the Sushila Agarwal versus State and City Delhi case. So this, however, while granting anticipatory bail, the court may provide in the order a condition as to the limitation of time.
Does res judicata apply to bail application?
So the principle of res judicata stricto sensu doesn't apply, but sir, repeated bail applications are not entertained on the on ground of abuse of judicial process, sir.
Can the application for bail be given even in the Supreme Court?
Sir, that is not the regular procedure to be followed. However, sir, the Supreme Court has the jurisdiction to give bail.
Okay. Tell me, can accused become a witness in his own case?
Yes, sir. Under Section 315 of the Code of Criminal Procedure.
Okay. Who can grant pardon to co-accused?
So the court can grant pardon under Section 306 of the Code of Criminal Procedure.
What is trial in camera?
So in-camera trial is the one which is conducted by excluding public from accessing the trial or being present there. It is conducted only in presence of the parties in question, sir.
Okay. Then tell me, what is protest petition?
So protest petition is a document which is filed by the complainant or the victim after a closure report has been filed, persuading the court to take cognizance of the case.
Who can record the confession of the accused?
Sir, under Section 164, it can be recorded by the judicial magistrate.
Okay. What is primary evidence?
So primary evidence is a form of documentary evidence wherein the document itself in original is produced before the court for its inspection.
Okay. Tell me, can a witness be compelled to answer a question which may interrupt him in an offense?
Sir, yes, in a court he can be compelled to answer such a question under Section 132.
132
of the Evidence Act, sir.
Okay. Then what is the evidentiary value of admission?
Sir, admission is provided under Section 31 of the Evidence Act. It's not a conclusive proof of the facts admitted, but it can be used as estoppel in an appropriate case, sir.
Okay. Tell me, have you heard the narco test?
Yes, sir.
Is it constitutional or unconstitutional?
Sir, it is constitutional if it is administered with the consent of the person to whom such test is administered, as held in the Salvi versus State of Karnataka decision, sir.
Okay. Then, what is the will the principle of res judicata apply to the habeas corpus writ?
No, sir. It doesn't apply. Is clearly held by the Supreme Court in Lallu Bhai versus Union of India decision, sir.
Okay. You know, section, मान लो suppose, for example, there is a civil case which is against the government.
Yes, sir.
ठीक है. क्या कोई प्री कंडीशन है या रिक्वायरमेंट है क्या आप डायरेक्टली सूट फाइल कर सकते हो अगेंस्ट द गवर्नमेंट?
Sir, there is a requirement of a 2-month notice period given under Section 80 of the Code of Civil Procedure. So that has to be complied with mandatorily, sir.
Why is notice given?
So the notice is given to ensure that the courts are not to correct the problem of pendency in the court because, sir, and it is expected that if a dispute can be resolved at the departmental level in the government, then it should be resolved at the departmental level, and unnecessary and frivolous litigation should be avoided, sir.
Is it is this rule applicable upon the semi-government?
No, sir, it's not applicable on the semi-government organizations.
Okay. मान लो suppose for example कोई PWD डिपार्टमेंट है, उसमें कोई एक्शन है, ऑफिशियल कैपेसिटी पे उन्होंने कोई मतलब कोई ब्रीच किया, कोई वॉयलेशन किया, सिविल राइट वॉयलेशन किया किसी पर्सन का, क्या उनके लिए भी नोटिस रिक्वायर्ड है?
Yes, sir. Yeah, sir, the requirement under Section 80 applies to government as well as public officers for acts done in the discharge of their official duty.
तो हम पार्टी क्या गवर्नमेंट को पार्टी बनाना उसमें नेसेसरी है या फिर वही पब्लिक सर्वेंट को ही हम पार्टी बनाएंगे?
Sir, it is not necessary that government should be made a party, but sir, a provision is made to, a provision is provided under Order 27, sir, Rule 5A, if I remember correctly, sir, to add government as a party and if the court feels that there is a need for the same to effectively adjudicate.
Okay. Then what is the constructive res judicata?
So constructive res judicata, it's an artificial form of res judicata as recognized under Explanation 4 of Section 11 of the Code of Civil Procedure, wherein, sir, any matter which might and ought have been made a ground of defense or attack is deemed to have been an issue for the purposes of operation of the rule of res judicata.
Okay. Tell me whether application for amendment shall be allowed after trial has commenced?
Sir, it can be allowed only in the exceptional case where the court is satisfied that even after exercise of due diligence, the person could not have made an application at a prior stage. So in that exceptional circumstance, an application after trial has commenced can also be admitted.
Okay.
As provided under the proviso to Rule 17 of Order 6, sir.
Yes. All right. What is an ex parte decree?
So an ex parte decree is the decree passed in absence of the defendant. So it's primarily dealt with under Order 9, Rule 6A of the Code of Civil Procedure. Okay.
Can a judge also pronounce a judgment which has been written by other judge but not pronounced?
Yes, sir. That is permissible under Order 20, Rule 2, so if I remember correctly.
Okay. What is temporary injunction?
As a temporary injunction is an interim order passed under Section 94C, read with Order 39 of the Code of Civil Procedure, to maintain the status quo and to prevent any obstruction to the effective disposal of the suit, sir.
Okay. Tell me what is the cross objection and who can file cross objection in appeal under CPC?
So cross objection as dealt with under Order 41, Rule 22 of the Code of Civil Procedure is passed by a respondent in an appeal, and he can file such cross objection. The general rule is that he can file it only against the plaintiff, but if he can file it against the co-respondent as well in the limited case where deciding on such issue is material to decide his dispute with the plaintiff.
What is summary suit?
So summary suit is dealt with under Order 37 of the Code of Civil Procedure, is the one wherein is the one which is instituted in case there is a liquidated demand of sum of money guarantee or on an enactment. So in cases where the precise amount that the party wants to recover is known from the very beginning, and the special feature of such type of suit, sir, is that the defendant needs to obtain a special leave to defend for him to exercise or present his defense. And unlike other suits, this right to defend is not as a matter of regular procedure available to him.
Okay. What is difference between reserved forest and protected forest?
Yes, sir. Reserved forests provide for a greater degree of protection as when compared to protected forests. So in case of reserved forests, we see that a detailed procedure has to be followed, beginning from the appointment of a forest settlement officer, and then he settles the claims. And it's only after that detailed procedure that a forest is designated as a reserved forest. While such procedure is not followed in case of designation of forests as protected forests. So another material difference is that in case of reserved forests, activities like pasturing or right to way, right to forest produce, all these are not permitted unless they have been explicitly admitted by the state government in the notification under Section 20. However, sir, in case of protected forests, such rights are available unless expressly prohibited by a special notification to that effect by the state government. So the difference lies in the degree of protection primarily.
Okay. So tell me, what is the pecuniary jurisdiction of District Court of Himachal Pradesh?
I am sorry, sir. I'll have to brush up my knowledge on this area.
Okay. Just tell me, can additional accused be summoned after delivering judgment with respect to co-accused?
Yes, sir, he can be, as recently held by the Constitutional Bench in the decision of Sukhpal Singh Khera versus State of Punjab. So before the sentencing and after the conviction, such exercise of power can be made, as trial in case of conviction is only concluded after a sentence has been pronounced.
Okay. Just tell me, suppose a senior police officer demand detention of the accused of police custody after the expiry of first 15 days.
Okay,
In
sir.
a case where some more serious offenses has been discovered to be committed by an accused in the same transaction, whether he is justified in asking for more police demand.
Sir, under Section 167 of the Code of Criminal Procedure, the period of police custody is limited to 15 days, and police custody beyond such period cannot be granted. So, sir, my answer to that question would be negative.
Okay. आपने कोई recent...
Sir, yeah, sir, may I add, sir,
Yes.
to that, sir?
Yes, sir.
Sir,
Yes,
the Honorable Supreme Court in the decision of Senthil Balaji case expressed its opinion that beyond 15 days, police custody should be granted. But sir, as that was not in dispute in the said case, it is not considered as the obiter, and the rule as laid down in the Anupam J. Kulkarni case is the one which holds the law currently. So accordingly, sir, my answer is negative.
Okay. Is the compliance of notice of Section 41A of CRPC is mandatory?
Yes, sir, it is mandatory. In cases dealt with under IPC, it is mandatory, sir. But sir, as held in the Senthil Balaji case, in cases such as one under PMLA, it is not mandatory.
Okay. Whether victim has right to heard at the time of granting bail?
Yes, sir, he has the right to be heard as held by the Honorable Supreme Court in Ashish Verma at the rate Monu versus Jagjit Singh case, if I remember the name of the case correctly. So in that decision, the Supreme Court held the same.
Okay. Next question. Whether an accused is entitled for statutory bail under Section 167 Clause 2 of CRPC on the ground that cognizance has not been taken before the expiry of 60 or 90 days, as the case may be, from date of remand.
Sir, in my opinion, he cannot be granted statutory bail on that ground. The cutoff date is the date of submission of the charge sheet and not the date of taking cognizance. So, sir, that would not be material.
Okay. Just tell me whether the sentence imposed against the same accused by two different courts in two different trials should run concurrently or consecutively.
So the general rule is that it will run consecutively, but under Section 427 of the Code of Criminal Procedure, the court may direct the same to run concurrently.
Okay. Tell me, can session court grant anticipatory transit bail in cases like offense committed in Delhi and arrest apprehended in Punjab?
Yes, sir, it can be granted, sir, as held by the Honorable Supreme Court recently in the Priya Indoria versus State of Karnataka decision.
Okay. Then, who are the member of Juvenile Justice Board?
As said, Juvenile Justice Board consists of Sir, if I remember correctly, sir, there is two judicial magistrates and 3 persons having experience in child psychology or like fields.
Okay. Just tell me, if a child has committed a heinous offense, like punishment for 7 years or more, then who will try it?
Sir, we will see the age of the child first. If the child is below the age of 16 years, then he will be dealt with by the Juvenile Justice Board only. If the child is between the age of 16 to 18 years, then preliminary assessment will be conducted under Section 15. And if on the preliminary assessment it is found that the child or the juvenile should be tried as an adult, then he will be sent to the children's court. So in the children's court, then again an assessment will be made whether he should be tried as an adult or as a child. And if it is found that he has the maturity to be tried as an adult, then he will be tried as an adult by the children's court.
Can convicted child be kept in prison?
No, sir, he cannot be kept in prison. There are other, like sir, he can be sent to the special home. Sir, so in other, like observatory home is another institution, observation home, sorry, sir. So there's separate institutions created under JJ Act for children.
Okay. What is the full form of POCSO?
Sir, Protection of Children again from Sexual Offences Act.
Okay. Then tell me, what is the maximum punishment under POCSO Act?
So death sentence can be awarded under Section 6 for commission of aggravated penetrative sexual assault.
Okay. Suppose if the accused is convicted under POCSO Act and also under IPC, then which
Yes, sir.
punishment shall prevail?
So the higher punishment, the one which is greater in degree, that will prevail.
Okay. Have you heard skin to skin contact case?
Yes, sir, I've heard about it.
His
Yes.
name?
Sir, Attorney General of India versus Satish and others.
Okay. Can a woman be liable under Section 354 of IPC?
Sir, I believe, sir, as far as I can recall, Section 354 uses the word man. So, sir, I think she cannot be held liable.
Can husband file case against wife under DV Act?
No, sir, that is not permissible, as the protection is available only to women under the Act.
Okay. How many relief are available to aggrieved person under DV Act?
Sir, there is the relief of protection order, custody order, sir, compensation order can be granted, sir, residence order can be granted. So these are some of the reliefs that I can recall.
Okay. What is the legal aid scheme?
So the legal aid scheme has been enacted with a view to forward the goal of Article 39A, that is to provide quality and free legal aid to persons in need. So that is my knowledge in this area.
Okay. Suppose you are a judge. You were
Yes.
insulted in the open court. What
Yes, sir.
are the remedies available to you?
Sir, one remedy would be that since this is an offense under Section 228 of the Indian Penal Code, sir, then under Section 345 of the Code of Criminal Procedure, sir, I can take direct cognizance of it, and accordingly with minimal punishment like sentence till rising of the court, the person can, with such minor form of punishment, the person can be made to realize his mistake as well as not penalized excessively. So I can also make a complaint if the case is of such a nature, then I can also prefer a complaint under Section 195 read with Section 341 of the Code of Criminal Procedure for the same.
Okay. Can children of void marriage become to co-partnership by birth in joint Hindu family?
No, sir, as recently clarified by the Honorable Supreme Court in Revani Siddhappa versus Mallikarjun decision.
Okay. Just tell me, whether the statement recorded by the investigating officer under NDPS Act treated as a confession?
So yes, it will be treated as a confession. So as recently, sir, but that confession cannot be made admissible as held in Tufan Singh versus State of Tamil Nadu decision.
Okay. Can anticipatory bail granted under SC/ST Act?
I'm sorry, sir, I have limited knowledge on this subject matter.
Okay.
I'll read about it, sir.
Okay, yes. What is closure report?
The closure report is the one wherein, after conducting the investigation, the investigating officer is of the opinion that no offense is made out and the case is not one which merits cognizance to be taken by the court. So in that case, a closure report is filed under Section 173.
Okay. What property may be transferred under TPA?
Sir, pardon, sir, your voice is not audible, sir.
Okay. What property may be transferred under TPA?
Sir, TPA deals with both movable and immovable property. So both can be transferred, although, sir, for instruments like lease and mortgage and sale, it deals exclusively with immovable property, whereas instrument of gift, it applies both to the case of movable and immovable property.
Okay. What is void agreement?
The void agreement is the one which is not enforceable by law, as defined under Section 2G of the Indian Contract Act.
Okay. What is an actionable claim?
So actionable claim is refers to the beneficial interest of a person in a movable property not in his possession, or to an unsecured money debt. So
How many types of mortgage under TPA?
Sir, under TPA, sir, can I take a few seconds to recall, sir?
Yes, yes.
So there's 6 types of mortgage.
Please name.
Yes, sir. So there's simple mortgage, there's mortgage by conditional sale, usufructory mortgage, equitable mortgage, English mortgage, and anomalous mortgage.
Okay. Can a minor become lessee?
Sir, a minor, sir, although a minor is not competent to enter into a contract, I believe, sir, he can become a lessee, but the obligations of paying the rent cannot be enforced against him. So as interpreted by the Madras High Court in, sir, I'm not able to recall the exact name of the case, but so the court held that although a minor is not competent to enter into a contract, but he can enforce his rights in the capacity of a lessee or a mortgagee if he is already complied with his part of the agreement.
Okay. What is the relationship between lawyer and client?
Sir, it is a privileged relationship. It is a relationship wherein they are able to, in a candid manner, share advice and communicate with respect to the case. So this relationship and the communication that they make in the course of employment is also given a special protection of law under Section 126 of the Indian Evidence Act.
Okay. What do you mean by pledge?
So pledge is a particular type of bailment wherein the goods are bailed for the purposes of serving as a security for any loan or a performance of any engagement.
Okay. What is gender stereotyping and what is the effect of stereotyping?
Yes, sir. So gender stereotyping is making preconceptions and generalizations about the role and attributes of women in society. So gender stereotyping has a very adverse impact on a society. It leads to perpetuation of notions, perpetuation of roles of women, and it also, so it leads to another adverse impact of gender stereotyping is that it leads to division in the society. of two genders, division in terms of the roles to be performed by them, and it is a violation of their right to equality, sir.
Okay. Is there any judgment which discussed about in which discussed the gender stereotyping?
Yes, sir. Recently, the Honorable Supreme Court in Aparna Bhatt versus State of MP discussed the concept of gender stereotyping.
Yeah. Now, see, DV Act used the word nature of marriage.
Yes,
What do
sir.
you mean by nature of marriage?
So the term nature of marriage is interpreted by the Honorable Supreme Court in Veluswamy versus Patachayamal case, is that it should have the core attributes of marriage. For example, both the parties should have attained the age for entering into a legal marriage. Both the parties should have been living together, cohabiting together for a long time. They should be presenting themselves to the public as a couple. So factors like if they are financially pooling the resources, managing domestic work like married people. So these are the factors which will help us arrive at a conclusion whether two people are living in a relationship which is in the nature of marriage or not.
Okay, tell me, is the same gender harassment complaint maintainable under Sexual Harassment of Women at Workplace Act?
Yes, sir. Sir, I remember that with the West Bengal High Court, in the West Bengal High Court, Honorable Justice Sabyasachi had delivered a verdict providing for the same. So I'm not able to recall the exact name of the case.
The word insist. What do you mean by insist case?
Sir, pardon, sir.
Incest case.
Sir, incest case.
Incest case. What do you mean by incest case?
Sir, as far as my knowledge is concerned, it is the act of having sexual intercourse with people in the prohibited degree of relationship, sir.
Okay, right. What is the remedy available to the victim in the case on a refusal of police officer to register the FIR?
I said a person can approach under Section 154, Clause 3 to the Superintendent of Police for registration of FIR. So if that is also not, the FIR is not registered after that also, then resort can be made under Section 156, Clause 3 by way of an application to a magistrate directing registration of FIR. So if even after that the FIR is not registered, then High Court can be approached under Section 482.
Okay. Whether an aggrieved person has a right to claim that an offense be investigated by any particular agency, like CBI, of his choice.
No, sir, such a right is not available. Sir, although if the person has a reasonable ground to believe that the investigation is not being carried out fairly by this particular investigation agencies, the person can file an application to the High Court, but with on very strong grounds, the High Court will then transfer the investigation to another agency and not as a matter of routine, sir.
Okay. Just tell me, are the statement of the witness made to police required to be signed by the witness under Section 162, Clause 1 of CRPC?
No, sir, they should not be signed as clearly provided under Section 162, sir.
Okay. Just tell me, if confession was recorded not by magistrate, but by his clerk in the presence of magistrate.
Okay, sir.
Is it valid?
Sir, my understanding is that the mere presence of magistrate is not sufficient. The magistrate should be actively involved in the process of recording the confession, like he should properly explain to the accused that it can be used as evidence against him. He should make it voluntarily. So, sir, merely because the magistrate is present in some part of the room will not make it a valid confession. But if in all practical and real sense, the confession has been recorded by the magistrate and only typed by the clerk, then I feel there is no problem in relying on such confession. But otherwise, I think so. It is problematic if he is not actively involved in the process.
Okay. Just tell me whether the content of the memory card, pen drive, CD submitted to the court along with the police report can be treated as evidence.
Sir, sir, can I take a few seconds, sir?
Yes, you can.
Sir, it can be taken as an evidence if it complies with the provisions of the Indian Evidence Act. Sir, because so the contents will be treated as a document, and if it complies with the provisions, I believe it can be taken as an evidence.
Okay, just tell me, can the judicial magistrate pass an order of further investigation suo motu after taking cognizance?
Yes, sir, that is permissible, sir, as clearly held by the Honorable Supreme Court and we know by Haribai versus State of Gujarat decision.
Okay, just last question. Can magistrate
Yes.
take cognizance in respect of person against whom no challan has been filed?
Yes, sir. So even if closure report has been filed and no charge sheet has been filed, a magistrate is competent to take cognizance if it feels that on the basis of the material submitted by the police and the documents submitted in the police report, the case merits cognizance of the court.
Okay. Just last and final question. Why we selected for you this post?
Sir, I think I am a very hardworking person. I'm a compassionate person, and I'm also a very goal-oriented person, sir. I like to keep improving myself and becoming a better version. So these qualities would help me to discharge the functions of a judicial officer in an effective way and, sir, stand to your expectations.
Okay. Thank you and all the
Thank you,
best.
sir. Thank you, sir.